Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe. It helps our channel grow. For today's case, it is Long Lake Township versus Todd Maxson. In this case, Mr. Maxson had some property on which he was violating some zoning ordinances by basically turning it into a junkyard. He had so many old cars and things stored on his property. He was basically a hoarder, and the county was displeased because he basically turned it into a junkyard. And so, yeah, the way that they found this out, though, is what brings us to our current case. They found it out by flying a drone over his house. So that's kind of interesting. They found it out by drone. And so the court analyzes whether or not the fact they viewed it by drone makes it an unreasonable search and seizure. So we'll take a look at this. Let's get started with this. In 2018, the plaintiff filed the instant civil action alleging defendants have significantly increased the scope of junk cars and junk material being kept on their property since a 2008 agreement, and that such activity constituted a illegal salvage or junkyard in violation of Long Lake towing zoning. In support of these allegations, the plaintiff has attached aerial photographs taken in 2010, 2016, 2017, and 2018. The defense moved to suppress the aerial photographs and the evidence obtained by the plaintiff for the illegal search. The defense argued that the aerial surveillance of the property and the photographs taken by drones of the property and surrounding areas constitutes an unlawful search in violation of the Fourth Amendment. Defense argued that the instant case is distinguishable from precedent involving manned aerial surveillance because, unlike fixed-wing aircraft and helicopters, which routinely fly over a person's property, drones are equipped with high-power cameras and do not operate at the same altitudes in helicopters. Okay, so what we have is the idea we're viewing from the air. And we do, of course, have case law on this. And the case law has been, so far, that if you can view it from a helicopter or you can view it from an airplane at the standards they fly in, if you can see it with a human eye, then it's fine. And so maybe a drone is different because it flies at lower altitudes or it flies with more powerful cameras or something. But that's the argument, right? Does the fact that we're flying lower or using cameras change the legal analysis? Let's read some more. We note that the photographs in the record clearly show that very little, if any, of the defendant's property is visible from the ground due to combinations of buildings and trees. In response, the plaintiff argued that defendants failed to establish how the use of a drone to capture the photographs violated Fourth Amendment right because their property was visible from above. So the government says, well, it's in plain view. You know, we were able to see it by looking at it, so we could just see it. So the trial court denied the motion to suppress, finding defendants did not have a reasonable expectation of privacy, which is kind of in keeping with the law in general with aerial flights. But then again, of course, this is in a different context. It's not a helicopter, it's not a plane, it's a drone. So let's read some more. The Fourth Amendment of the United States Constitution and its counterpart in the Michigan Constitution guarantees the rights of persons to be secure against unreasonable searches and seizure. The Fourth Amendment does not apply to private parties who are not acting as agents of the governmental entity. However, the Fourth Amendment may protect parties from unreasonable searches and seizures committed by a governmental entity in civil cases if the civil case can be considered quasi-criminal and the search and seizure was committed by a governmental entity in pursuit of action. So there are some civil cases that are technically qualified as civil, but they have some quasi-criminal elements to them because of some of the fines that are associated or otherwise. There's no dispute that the drone operator here was acting as an agent for Long Lake Township. The Long Lake Township is a governmental entity, and the Long Lake Township seeks admission of its own allegedly illegally obtained evidence. The first inquiry in search and seizure issue is whether the search occurred under the Fourth Amendment. The area immediately surrounding and associated with the home, also known as curtilage, is part of the home itself for the Fourth Amendment, as we've discussed before. In general, a search and seizure within the home or its curtilage without a warrant is per se an unreasonable search under the Fourth Amendment. However, what a person knowingly exposes to the public, even in his own home or office, is not subject to the Fourth Amendment. So, yeah, the curtilage is protected, but at the same time, if it's in plain view, it doesn't even matter if it's inside your house. If it's in plain view, you know, you've exposed it to the public. So your curtilage is protected, but if it's exposed, it's exposed. We note that the plaintiff does not on appeal seriously dispute where the area is curtilage. So we got that covered. It is curtilage. So we expressly do not decide that issue. Instead, focus on when they have actual privacy. So yeah, this is part of the home. It is part of the home. The home is special, but the home being special and all, still, if you're exposing it to the wide world, it's a little bit on you. In California versus Sorello, the United States Supreme Court determined whether the Fourth Amendment is violated by aerial observation without a warrant from an altitude of 1,000 feet of a fenced-in backyard within the curtilage of a home. The United States Supreme Court rejected the respondent's argument that no government's aerial observation of his yard was permissible without a warrant, because the yard was in the curtilage of the home. The court concluded that the respondent's expectation that his yard was protected from the officer's observation was objectively unreasonable. The court determined that an officer's observation took place within publicly navigatable airspace in a physically non-intrusive manner, and any member of the flying public could have seen what they seen. So it was exposed to public view for anyone who happened to be in the air. Only a few years later, the United States Supreme Court held in a plurality opinion that police observation of a greenhouse located in respondent's curtilage from a helicopter at an altitude of 400 feet did not violate the Fourth Amendment. So helicopter, 400 feet, that's okay. Relying on the prior case we discussed above, the plurality concluded that Riley could not have reasonably expected his greenhouse was protected from the public or official observation from a helicopter that had been flying in the navigable space for a fixed-wing aircraft. So, in the case of a plane or a case of a helicopter, even if they're flying at 400 feet, so like anyone could have seen it. So, whoever happened by could have seen it. So, the police are in the same position. The plurality stated it was of obvious importance that the helicopter in the case was not violating the law. Additionally, the plurality notes that the record did not reveal there were any intimate details connected with the use of the home or curtilage observed, and there was no undue noise, wind, dust, or threat of injury. So it was physically unintrusive. It wasn't doing anything that was special. It's just viewing what you could view from the air. As the defendants tacitly concede, the prior case establishes that defendants could not have reasonably expected the activities and items on their property protected from public or official observations made by a human being from a publicly navigatable airspace. Conversely, unrefuted photographic exhibits of the property taken from the ground seem to establish a reasonable expectation of privacy against a less casual observation from a non-aerial vantage point. We conclude that much like infrared discussed in Kylo, low-altitude, unmanned, specifically targeted drone surveillance of a private individual's property is qualitatively different than the kinds of human-operated aircraft overflights permitted by the other cases. We conclude that drone surveillance of this nature intrudes into persons' reasonable expectations of privacy, so surveillance implicates the Fourth Amendment and is illegal without warrant or traditional exceptions. So, obviously, we're in a different context than we've been before, right? We're not in the context of an airplane. We're not in the context of a helicopter. We're in the context of a drone. And that different context might yield a different result. And this court says it does yield a different result. That this is qualitatively different. That they're flying lower. They're flying with more powerful cameras. Potentially flying for longer periods of time. That's the idea of a drone just being constantly hovering over your home is problematic. So they say, well, okay, there's some qualitative differences here. But you could obviously disagree with that if you're so inclined. I mean, how much different really is a drone from a helicopter? The helicopter is flying at 400 feet. So if the drone is flying at 400 feet, is the only real difference that's a human being versus a camera? So what if we create a camera for the drone that is the same as a human eye? So it shows the same amount of detail that a human eye could show. Is that different? Is it different if we then are able to zoom in on the photograph and stuff like that? So yeah, what is the logic here that ultimately hints this? Is it that a human has to observe it in real time? Does the cameras change the analysis? What exactly is changing the analysis here is a little unclear, but they think there's a qualitative difference, which there might very well be for the reasons we've talked about. Although non-compliance with FAA regulations does not establish Fourth Amendment violations, such regulations are relevant to what a person might reasonably expect. So there was some suggestion here the flying of this drone violated FAA guidelines. And they say, well, violating FAA guidelines in and of itself is not a Fourth Amendment issue, because it's not. If you're just violating FAA guidelines in general, there's no Fourth Amendment there, right? There's some sort of FAA regulation, but not Fourth Amendment. But it would be, but it is relevant to what a person would expect with respect to their privacy. The relevant regulations require drone operators to keep drones within visible observation at all times, fly drones no higher than 400 feet, which is the same height as that helicopter before, refrain from flying drones over human beings, refrain from, I don't even know what that means legally, and obtain a certification. Such rules reflect the fact that drones are qualitatively different from airplanes and helicopters. They are vastly smaller and operate with little more than a football field's distance from the ground, which is a little bit closer than that helicopter, and also using cameras to boot. Although the United States Supreme Court rejected ancient understanding that land ownership extends forever, so yeah, when planes first came into place, the common law was your property rights extend to the heavens. And then when planes came along, they're like, yeah, no. It wasn't really an issue until someone invented an airplane. Landowners are still entitled to ownership of some airspace above their properties, such that intrusion into that airspace will constitute trespass. That's logical, right? So just because it doesn't extend forever doesn't mean that it doesn't extend at all. Drones fly below what is usually considered to be public or navigatable airspace. Consequently, flying them at legal latitudes over another property without permission was reasonably expected to constitute trespass. So if they're physically trespassing by being in that airspace, then it is an unreasonable intrusion. So that might be a difference that cuts this analysis. We therefore reverse the trial court's order, denying the motion to suppress evidence, and remand for entry of an order suppressing the photographs taken. And we do not retain jurisdiction. So go back to the trial court with any further complaints. And then the dissent here says that the majority's conclusion is distinguishable from otherwise binding precedent. I'm too deeply concerned about the particularly intrusive nature of drones as compared to other aircraft, but I do not believe this concern provides us a basis to sidestep the precedent. So the dissent thinks that the precedent dealing with airplanes and the precedent dealing with helicopters reads onto this issue. And although drones present new issues, that's not enough to deviate from the precedent, which is also a perfectly reasonable opinion. So both sides of this are presenting perfectly reasonable logical conclusions. I guess it's up to you to figure out which is more logical or more persuasive. Thus, that brings us to the case of Long Lake Townshop versus Tad Maxon. In this case, Mr. Maxon was basically running a junkyard, and the reason that the government knew about it was because of overhead drone photographs. And drones are presenting some potentially different problems. They fly lower, and they fly with high-powered cameras, so they're a little bit different than helicopters or planes. The question is, are they different enough? And there's a dissent on this issue, so the court does not completely agree. So I suppose this issue will definitely come up again, and the Supreme Court will eventually have to deal with this issue in one way or another. I'm not sure this is the case to deal with it, but this issue is going to come up again, and the use of drones by the government to surveil property, is going to be an issue that's going to have to be resolved. Like, can they do it continuously? Could they theoretically have drones continuously flying? I mean, isn't that some sort of really scary situation? So, and the Supreme Court's going to have to deal with that someday, but I don't think it's going to be super soon. But I could definitely see it coming up within the next couple of years. But at least for a moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.